Hi folks, my name's Tim Forshee. Thought we'd take this opportunity to clear up some of the developments that have occurred with regard to the ATF's new pistol brace rule, Rule 2021 R08, that have happened just in the last few days. First of all, let's talk about the issue of trust eligibility. I did a video earlier where I indicated that it made no sense whatsoever that the ATF wouldn't allow us to register these into trust. It still doesn't. The point being, however, was that we all believed that the January 13th, 2023 date was when the actual rule had been listed on the Federal Registry. It turns out that was not the case. ATF made an error on that. Their original website notification clearly stated that if you had the item in your trust prior to January 13th of 2023, that you could then go ahead and use the trust to register that item as an SBR. If you go to the ATF website now, sometime since last Friday, they've actually changed that. It no longer says January 13th, 2023. It now says once the rule is uploaded to the Federal Registry. So whenever that happens, that will be the tolling date of that deadline. So now that would indicate that you can actually use your trust to register your new SBR after all. I would strongly suggest that you add the serial number and the description of your Title I pistol to the attachment A, which is the inventory of the items owned by your trust, as soon as possible, so that that item is in fact owned by the trust prior to the date of publication on the National Registry, whenever that turns out to be. I would also strongly encourage you to date and sign that attachment A before a notary with a notary stamp affixed to it. That way we can prove what day that was listed on your attachment A as being owned by your trust. So by my best reading and the best reading of everybody that I've talked to, if you act now and get that item listed on your trust, you will still be able to list the item as owned by your trust and still be able to waive the $200 transfer tax associated normally with registering that as an SBR on a Form 1. The original answer to the FAQ post on the ATF website was that unless your trust had possession of that item prior to January 13th, that you would have to register the item as an individual tax-free, then you could then transfer it from yourself as an individual to your trust via a Form 4, but unfortunately that would involve the $200 transfer tax. So basically they said that the $200 transfer tax was waived as a result of this amnesty period, but the only way that any of us could take advantage of that would be to go ahead and do a tax-free transfer to ourselves, then do a taxable transfer from ourselves to our trust. So same price, double the hassle, some amnesty. But the good news is it turns out that that's not true because ATF has not yet published the item in the National Registry. So you literally could go to that each morning and check to see if it's been published or not. That might be your best bet. But once it is published, that 120 days will start and it will then be too late to retroactively add the item to your trust. So now's the time to act. There's another issue at play as well, however, and that is that it appears that any foreign-made pistols with stabilizing braces attached will now be in violation of Title 18 U.S. Code Section 922R, what we always call the 922R provision, since they're now considered to be rifles. This would apparently leave destruction of the item or surrender of the item to ATF as your only options in order to comply with this new rule. Lots of money's at stake here, folks, and the constitutional concept of taking is going to apply. The government can't legally pass an ex post facto law that deprives you of valuable property without providing adequate compensation for that property. Should this shake out in court that this is unenforceable, which I believe it will, it's going to take time. In the meantime, be aware of this very horrifying development. Notify your representatives in Congress that this is not going to be tenable to you, that this needs to be changed, that this is unconstitutional, it's illegal, it deprives you of your hard-earned property. And don't forget, some of these 922R guns are quite expensive. Some of these imported guns, we're talking thousands and thousands of dollars. That's something to really give some thought to. So perhaps we can get behind this and unite a little bit and get this problem resolved. The next issue that's come up is this so-called 88-day trap. A lot of rumors on the internet that this is all a scheme for ATF to arrest all of us on felony charges. The theory goes something like this. Any NICS background check that takes longer than 90 days automatically results in an automatic denial of the approval for the transfer of the firearm. So, the theory goes, ATF will simply wait more than 90 days for that automatic denial to kick in. Then they'll come and arrest all of us, with us having provided them with all the evidence they need to prosecute us via the pictures that we sent them showing the configuration of our Title I pistol as an unregistered Title II short-barreled rifle. I honestly feel that this is a pretty substantial exaggeration of what I seriously think, in my opinion, is a very small risk. First of all, anyone who's ever submitted a Form 1 or a Form 4 transfer request knows that it's very common that it takes more than 90 days, especially with Form 4s, well over 90 days. And to my knowledge, this supposed scheme to arrest people that go beyond 90 days has never been implemented before. If they wanted to implement it now, they could have done that before as well. And let's not forget this so-called 90-day rule is actually a limitation on the government's powers imposed by 28 Code of Federal Regulations, Section 25.9, that states that the government is required by law to purge all such data within 90 days. So they've routinely allowed themselves 2 days worth of wiggle room, and they always destroy these documents after 88 days have transpired, thus the so-called 88-day trap. This 90-day limitation actually only applies to 4473 clearance forms, not to Form 1 and Form 4 forms. As we said earlier, those almost always exceed 90 days without a denial. Yes, you do, in fact, fill out a 4473 when you pick up your Title II item after your Form 4 or Form 1 has been approved and you got your tax stamp. But if you remember right, when you fill that 4473 out, no NICS background check is required at that time. In fact, 4473 question number 28 clearly states just that. No NICS background check was performed or required because the person has already passed the background check on their Form 4 or their Form 1. So the only way that this is indeed a trap is that if ATF intentionally sits on these Form 1 applications for greater than 90 days, then obtains a de facto denial due to their own intentional delay for that very purpose, then they send agents out to arrest us in bad faith on the strength of evidence that we were told to provide the government in good faith as an attempt to comply with a very poorly considered and drafted new rule. And if you're sitting there shaking your head about how naive Tim Forshee is, let me point out one last important fact. 26 U.S. Code Section 5848 clearly states that no information or evidence obtained from an application or registration or records required to be submitted with same may be used directly or indirectly as evidence against that person in a criminal proceeding with respect to a violation of the law which occurred prior to or concurrent with the filing of the application, unless the information provided was intentionally falsified. Which basically means that those of you that think that this is a trap, there's a law that says it can't be a trap. Now, again, I'm not naive. I know you aren't either. And I certainly have more than a healthy dose of cynicism regarding this new development and the government's job in general of late. But I can't bring myself to believe that the ATF would be naive enough to even try to entrap millions of law-abiding Americans in such a huge and easily provable as illegal scheme. I think any reasonable judge would find that this was entrapment and would throw the case out immediately. I, for one, have to hope and pray that the government has got better things to do than create as many as 40 million new felons out of perfectly law-abiding citizens at unfathomable expense of time and money, when that effort is doomed to failure and would almost certainly bring shame and embarrassment to the Bureau, as well as, perhaps more importantly, its bureaucrats. So anyway, that's the latest in terms of the developments that have happened over the last 72 hours on this wonderful new rule. We'll keep you posted as further interpretations and explanations are required. But in the meantime, I strongly suggest you get an NFA Trust drafted up. Again, go ahead and go online to azccwonline.com or my personal website, forsheelaw.com, and we can hook you up with an NFA Trust in just a few days. Strongly suggest that you do that. And again, make sure that you notarize the date that you've put that item on your attachment A to your NFA Trust so that when this does go in the National Registry, we can then pop everything in the mail and hopefully get your tax-free new SBR designation. I know, I don't like it either, but I think it's the best of all the bad options. All right, in the meantime, stay safe. Thanks for tuning in. Be sure to like or comment below. Thanks much.